Noon, everyone. We will go ahead and get started. I want to first introduce myself. I am Dr. Candace McClendon, the Executive Director of the Mississippi Cannabis Trade Association. And I would like to introduce our board members who will facilitate this webinar for us. First, we have Clare Millette, who is a board member, but also partner at Cosmich, Simmons, and Brown. And we also have Slates Veazey, who is a board member, and he is partner at Bradley Law. We are so excited that you all joined us. We've been getting tons of emails and calls about updated regulations, and we just thought as an association, it was important for us to just make sure our members and just people who are part of the cannabis business community in Mississippi have this vital information so that you all are operating and having successful businesses. So we will go ahead and honor your time and get started. If you all have,
no, sorry, go ahead.
Oh, I was just going to mention, if you all have any questions, please drop them in the chat. I'll be monitoring the chat and I'll let Claire and Slates know as they come through.
Great. Well, good afternoon, everyone. I'm Clare Millette, and I'll let Slates introduce himself. But as Candace said, I'm a partner at the law firm here in Jackson, Cosmich, Simmons, and Brown. And today we're going to talk to you all about some of the changes and updates in the Medical Cannabis Act that we have that were a result of this year's legislative session, and also some of the updates in the regulations that have been published by the Department of Health. Can everybody hear okay? I just see a message that that some folks are having some problems hearing.
I can hear you fine. Let's see.
How about me? Am I coming in clear? Okay.
All right. And then Slates, I don't know if you want to introduce yourself as well a little bit, sure. And then I'll put this PowerPoint up. Everyone bear with me. I'm not very tech savvy, so I'm going to try to share this. Share this PowerPoint in a second when we talk through it, but go ahead.
Yeah, thanks, Claire, and thanks, Candace, for helping organize this, and I appreciate everybody for joining. As they said, I'm Slates Veazey. I'm with the law firm of Bradley, Arant, Bolt Cummings. I am in the Jackson office. We have offices really from Texas all the way east to Florida and up to DC. Formed a cannabis group back in 2017, 2018, and are working in that space in the areas in our footprint. So I look forward to talking with y'all today about some of the new things that have happened here in Mississippi this year.
All right. Well, I'm going to try to share my screen and see if I can get this PowerPoint going. All right, everybody. As I said, we're going to talk through some of the law and the new laws and regulations related to our cannabis program here in Mississippi. Today, of course, we encourage all of you guys to take a look at these changes, take a look at House Bill 1158 that's got the information that we're going to talk through. Also taking a look at the new regulations that were published in May that apply to pretty much all medical cannabis business entities. I don't know that there's been that much updated with regards to dispensaries, but for the other entities that are governed by the Department of Health, there has been some, and we want to talk through that with you and just kind of highlight some of the things that you definitely need to be paying attention to while operating your cannabis business. So just so everyone's aware, at the end of the 2023 legislative session, Governor Reeves signed House Bill 1158 into law, and this incorporated several changes to the existing medical cannabis program that was signed into law in 2022. So if you had been following it very closely last year or just jumping back in this year, there've been some changes. I think they're good ones, particularly with respect to patient access, and we're going to talk through some of that in a minute. In addition, the Department of Health has published some updated regulations, I believe, in May of 2023, and they pertain to business entities, advertising and marketing, work permits, and patient registry and ID cards. I also wanted to draw attention to the medical cannabis program's website. I know for most of 2022, we were being directed to the Department of Health and the Department of Revenue's website to get information about the cannabis program. And those websites are still up and running, and they have a cannabis page that has lots of great resources for you. But they have, and the Mississippi government has also created a cannabis website, and that's where you can find the licensing portal, and you can find updated regulations and a lot of helpful resources, including frequently asked question materials and things like that. So I wanted to include that website because it is relatively new, and if you aren't aware of it, definitely go check that out.
Yeah, that's a good thing to point out in case you weren't already aware, and it relates specifically to the updated regulations, because I know when they came out, the Department of Health website had not updated the regulations on their page, and then they weren't here, and I had talked to some people about some changes, and then they called me and were like, are you sure that's a change? Because I'm on the Department of Health's website and it still says X, Y, or Z. So, but in addition, yeah, like what Claire said, and they have a business search function on there. It's a very easy way. I want to know what all dispensaries are in, Tate County or Hines County, and you just type it in and there it goes right there. So that's a good resource to keep following, and understand that they may be updating that even with some potentially some like patient count, like a ticker or something that might update every so often. So it'll be a good resource to select as a favorite on your web browser.
All right. Well, on that note, these are some of the changes to the law with respect to patient access. And I know that we're all here for the most part today to talk about business entities, but I think we all know and agree that what is essential to this program more than anything is that we have patients and that can participate in it. And so I know that we all, there was a bit of a slow start. It's of understanding the process and getting cards issued. And there's been some great strides and changes made this year on getting that process expedited and helping people get approved for their cards and then access to their medical cannabis. So Slates, I don't know, have you taken a look at what our latest patient count is?
It's over 18,000 is the last I heard. I don't know if it's to 19 yet, but that's.
And that, I think that these changes went into effect during March, at the end of March or so. And from what I understand, we've had an increase, a spike from about 11 or 12,000 patients since then. So the process is really, it's proving to work because we've seen those numbers go up. But some of these changes that are really important are that there's no longer a state mandated drug testing requirement as a condition for receiving your cannabis card. Now, a practitioner, if that is part of their regular course of practice and how they're evaluating you, they can do it in their discretion, but it is not required as it once was. And so that is that's been a helpful and encouraging change. The prior drug testing requirement was concerning to people for a couple of reasons, and sort of created a chilling effect for people in trying to go and obtain legal medical cannabis. And so that has been lifted, and so now it's no longer required for receiving your card. And I think that you can talk with your practitioner if you or encourage people to talk to their practitioners a little bit more about that if they've got any questions on when that would be in play. The second thing on the list, I think, is huge. And this is that after issuing a written certification, the practitioner in his office and his or her office may assist the patient in registering for the card with the Department of Health. This is making the process go so much smoother because these doctors' offices are very, very familiar with what the requirements are for that need to be submitted for a medical card. So they work with the patients. They try to make sure that you have everything with you when you come, so you can then apply after getting that certification. The burden used to be on the patients, and that can be troubling. That it's you are logging into a portal, uploading documents. Even if you're tech savvy, sometimes that can be tricky. That was also prohibitive to people in areas where they didn't have access to computer portals and things like that. You're also dealing with very sick, very ill folks. We have a lot of elderly qualifying patients that want to participate in this program, and putting that burden on those patients was really slowing down the process and creating lag time in between getting a certification. And we're really losing a lot of those patients that may have been certified but not registered. Slates, I don't know if you want to talk about a few of these as well.
Yeah. I mean, I think back to your first one about the drug testing, as I appreciate it, that was a requirement by a separate state agency, and which ties into one we haven't talked about. I guess it's the fourth one on the list, that the practitioner isn't required to obtain any additional qualifications except those underneath the Cannabis Act. So no other, I mean, obviously boards of medicine can regulate physicians generally, but it looks like the legislature really wanted to hone in and say, with respect specifically to this program, the Department of Health and the Cannabis Act are going to be what governs. And I think that's important, so you don't have conflicting voices on that. But yeah, on the second point, and it also ties into the one about the last one about the process to get a card. From what I'm hearing, patients are seeing practitioners, submitting their information on the portal the same day of the visit, and even getting their card issued that same day, and if not, within, by the next day. So the process is sped up incredibly since this legislation was amended. Whereas before I'd heard it was taking north of 30 days for some patients to get their cards. So that's important. Another highlight here is that the qualifying patients don't have to see the same practitioner that issued the original certification for their follow-up visit. As I think as this program matures, you're going to see more practitioners in more parts of the state. So where originally a patient may have had to travel a certain distance to obtain their certification, now they may have someone closer, a practitioner closer, and can get the renewal that way. Let's see what else.
And that's an important point too, because as I understand, patients have a right to choose who their physicians are. And so this doesn't lock a patient in to returning to the same practitioner from the beginning. It allows you to get a second opinion or go see somebody different if that's what you'd like to do. And so that was an important one for patients as well.
Yeah, and I think one more thing that may not be here is that I think originally in the original law, the certifications were only good for 60 days before the patient had to, before they could apply for an ID card. And now they're good for 6 months. So they can be certified, hold the certification for 6 months for whatever reason, and then still obtain the card. It doesn't expire in 60 days as it did before.
Donna, I think I saw you may have raised your hand. I don't know if you've got a question. All right.
Well, I did see Claire, I don't know. Go ahead.
Oh, no. Doesn't have a question. I do have two from the chat that's related to telemedicine and also.
Candace, you're breaking up. I don't hear you very well.
I can read these questions.
Okay, yeah, I can't read them since I've got my PowerPoint up. So.
Okay. So the first question was, what are the chances telemedicine will be allowed for patients' first consult after this next legislative session? All I can really say on that is I've certainly heard that specifically is being discussed, and I think there will be some effort by some to get that added. I certainly can't speak for the legislature, but I know that it's at least a topic that's being discussed. I don't know, Claire, if you know any more on that, but
yeah, I do know that some physicians that are prescribers of controlled substances, they were given some leeway to do a lot of telemedicine during COVID, but I think that they are going now back where they need to have some in-person visits. I'm not sure how that would impact what happens here with medical cannabis. If anybody is on the chat as well that would like to offer some information, if you have some on that, that's great. But I don't know more than what Slates has offered.
Yeah, and I think Florida actually recently just amended their rules or their legislation on that and are allowing for telemedicine. So, more states that do it, maybe it'll influence our own legislators here. I see that Dr. Kinsey's on, a fellow board member. He informed us that there are over 19,000 patients and we're averaging about 900 a week. So that's great.
That's great.
He also is asking us, Claire, if we're aware of any regulations related to practitioners doing education events, patient drives with dispensaries and cultivators. You want to take that, or
So education events with practitioners and cultivators?
any regulations that govern the practitioners for participating in those education events?
I haven't seen anything that prevent them from participating in it. And we're going to get a little bit further in to the chat and be able to talk a little bit about some of the new regulations with respect to the materials and educational materials that can be now provided, but what needs to be in them and what needs to be addressed in them. And so I haven't seen anything that is preventing practitioners from educating. I think that the law is encouraging of education and understanding the importance of educating our qualified patients, our current ones, and our potential ones. So
I think that's right. I mean, I think what they prohibit is advertising in establishments by practitioners or referring patients to a particular establishment. But,
yes,
short of that, just simply having a patient education event, in and of itself doesn't seem to violate that. You never know the details, but I don't think there's anything that speaks on that directly, Dr. Kinsey. So those are the questions right now, Claire.
okay, all right. Well, change gears a little bit, but this is a really a big deal and a great new change in the law is regarding topical products. Dispensaries can now sell topical products that contain THC to patrons that are 21 years or older without the requirement of a medical cannabis card. So now the dispensaries need to be aware that they have to have the selling of these products are in a different area. You can't be selling them and having people without a medical card entering certain parts of the dispensary. So you do have to have it. You have to be able to be selling these prior to the access that you need an ID card for. But this is a great thing. This includes your pain creams and your lotions. I know I've seen a good bit of discussion about bath products. I think that's something that people talk a good deal about. Also using topicals. So anything that's not being ingested or digested by your liver, anything that is just a dermal absorption, that can be sold to anybody now. It has to be sold at the dispensary because the production part of it is still regulated and it still requires testing, but the consumer does not have to be a qualified patient. And I have heard a lot of people really, really excited about this because the pain creams are something that I think a lot of people have found a great relief in. Some of the people that some of our citizens in Mississippi that may be a little bit more wary of medical cannabis and haven't quite gotten past some of their concerns with the program, for some reason or another, something that is a cream seems a little bit more palatable for them, I guess, is one way to put it. And so this is a great update. I'm not sure. I know that there were products that were in the testing process. I know that cultivators and processors were jumping right on board on this. I don't know if they're for sale yet. They may be. If Slates, you may know a little bit more about that. But
I don't know for sure. I've certainly heard that people are businesses are planning to take advantage of this. And you kind of hit on this, Claire, but I think yes, they are for sale, says Dr. Kinsey. So that's great. And so, like you said, there may be some people out there that aren't necessarily willing or ready who would qualify, get a card and buy the other products, but they would buy one of these products, and bringing them to a dispensary might really change, public opinion, because they realize that these dispensaries are, very nice facilities and the security
highly regulated
like that. So it starts to help dispel any false kind of stigma surrounding this even more.
Absolutely. When people start to see how highly regulated this is, and that it is a medicinal program and it is regulated as such, they really are people that may have otherwise been a little bit holding back a little bit on embracing it. You can see that kind of start to fall away with it. This is something that it's highly regulated, and so when and this medicine is tested and all the things before it even reaches the hands of a qualifying patient. So the reason why these topicals, and one of the reasons why these topicals are able to be available without a card, is because that kind of absorption through your skin doesn't give the high that you would think of, the mental and the body feeling of a body buzz or high that the ones that the THC products that are ingested orally would. And so but it's also a good thing to, people start, if they maybe have achy bones and joints, muscles, get to use a product like this, and they really start to see the medicinal benefits of cannabis. So that is opening the door for them to really think harder about whether or not that they've got a condition that might be best treated with it. So this, in our marketing and advertising regulations that are put out by the Department of Health, this is a new section that wasn't in before. And what it's talking about is materials that are, that can be given to qualifying patients by whether it be practitioners or cannabis establishments, to help educate about the effects of cannabis. One of the things that's really important to know if you are coming up and drafting and getting ready to put out educational materials is that, and we're talking about pamphlets and brochures, documents, things like that, that can help educate, is that there's a requirement now that you have to have some information about the potential risks and side effects of cannabis use, including any risk of poisoning, and the number for the closest poison control center needs to be there. So that was something that is now expressly required in our advertising and marketing regulations. You'll see this is kind of at the end of them, and they're available on that website that we referred to earlier. Some of the other information that's listed here are just some guidelines, things that you may include. That is something that you must include. The rest of these are things that you may, but you can't, but they're allowing you, and they're expressly telling you now, the department is telling you that you can give some information about the differing effects of different strains, how you can administer cannabis and the different methods of doing so, the effectiveness of different strains based on what your condition may be and how those two things correlate, the differences in timeframes of how long something may take to take effect, whether or not it's a drink or it's something that you're eating or it's something that you're inhaling, what the difference or what the time is for you to start feeling those effects, so you know how to properly self-medicate with that. So those are some of the information. They also say that you could include information about substance abuse symptoms and information regarding treatment programs. And then, as deemed necessary or appropriate, instructions, warnings, directions on safe use. I mean, there are certain warnings and information that, as you all know, are in our labeling guidelines and regulations that have to be included. We're going to get to a major change with respect to some of our labeling in just a minute. But for the most part, there's always been a lot of detail required in our labeling and the information that needs to be on some of our packaging. But with respect to patient education and materials, they gave us, the Department of Health just gave some guidelines, a requirement and some guidelines on the kinds of things that they're comfortable with being in patient materials.
Yeah, and I think that was definitely needed, because the prior version of those ad and marketing regulations, when you read it, you were left with not knowing what, if anything, really, other than these very limited permissible branding activities that could be part of your marketing as a business, because otherwise it's a pretty draconian, honestly. I actually wrote a blog article questioning whether it may be a First Amendment violation, but at least here they're telling practitioners and businesses, you can do this for qualified patients, guardians, designated caregivers, because I mean, why it certainly seems odd that you couldn't educate the people taking the medicine about the effects of the medicine. So it was a nice ad for sure.
Right. Another change in the Medical Cannabis Act itself was in the section where the law gives authority to the Department of Health to draft regulation. And in that, they are saying now you can use a cannabis leaf in your logo and branding. Before that was prohibited. So that's something different. And also you can now, dispensaries can put pictures of what they're selling on their website. And this is important because that goes particularly, especially to a consumer's right to be informed and, you know, what is available and what does that even do? What does it mean? It all goes to patient education, which is very, very important in this program. And so now those products are available. You can take a look at them. However, the use of pictures, images of cannabis, the context is patient education. I think the Department of Health and our laws are still trying to keep a rein on that to keep this a medicinal program. And so those pictures used in an educational context is important versus somebody going out and getting high and consuming or something that is more appropriate for an adult use state. This is an important change for our labeling. For edible cannabis products, this is now the Mississippi standard symbol that must be included in your labeling. And as of July 1st, so as of right now, this symbol is required to be on all packaging, and it is available for download at the Department of Health. This is one of the most important, a very, very important change in our regulations. And anyone that is in any part of the business process that is involved with packaging and labeling and sales needs to make sure that you're seeing this, and this is part of the packaging that you're working with.
And I do understand that I know we're still in July, you know, if a business had already pre-ordered packaging that may have had a different symbol, I would just suggest maybe reaching out to the state. I think they might work with you and say, all right, well, when that packaging is out, you got to start using the standard symbol. But I mean, it's clear that going forward, this will be the symbol that is expected. And this is an easy one to detect non-compliance with, obviously.
All right, here are just some additional updates to the law itself. These were changes in the text that came into our law via the House Bill 1158 that we talked about. A few of them include, and they're in that any investigations by a licensing agency into a medical cannabis business or entity shall be confidential and exempt from disclosure under the Mississippi Public Records Act. So if there's a current investigation going on, the Department of Health will not disclose any of the materials or any of the information regarding that investigation until it's done. Another change is they have extended the period of time for dispensaries that are under construction. If a dispensary license is issued, but that dispensary was still under construction, the applicant must complete construction and open for business within 18 months. I believe before it was 12, if I'm not mistaken. I think that this is good. I think that, you know, we can all appreciate that this industry, you know, it's hard, it's wild to think that we're about a year and a half in, but you know, it's taken a little while to get off the ground, and it has been a strain on a lot of the finances of a lot of the industry, of the entities that are trying to participate in this market. And so this gives a little bit of breathing room for those that are trying to open dispensaries that were given a license under a construction provision and have not had the opportunity or ability to finish it. It also allows for some of the construction delays. I know right now across the country, we have delays in getting supplies. And so this is kind of allowing some breathing room for that as well, because that's out of the, as long as your orders are put timely, when you receive it can be out of your control. And so that is, this is hopefully giving a little bit more time for people to be able to reasonably finish that when finish those construction.
Yeah, that's important. Wearing my other hat as a lawyer, I'm a construction lawyer, and I can't tell. I mean, I don't know of construction projects that ever end on time. So, in addition to the revenue reasons and the patient count reasons, Claire mentioned, delays in construction are almost a guarantee. So this was needed for that reason too.
Absolutely. Let's see. Also, some other changes are Tier 6 cultivation facilities can have up to 2 locations. However, their canopy space may not exceed 150,000 square feet. That is now there's a limit on that. I think previously the Tier 6 did not have a cap on it, but it does now. So that was a change. Another change is individuals with an economic interest in a licensed testing facility. Let's see, hold on. I think that this is covered, but basically, did I put this in here wrong? I can't read it because of what's on front of it. But basically, if you're in a testing facility, you can also have a transport license, because the transport, it just made sense. The testing facilities needed to be able to go and get those samples. And so they had to have a legal ability to do so. And so a legal avenue for doing so. So now if you have an interest in one of the transport, or you get a transport license, it used to be those testing facilities had to be wholly independent, but I think that getting the product to them without them being able to have any sort of other interest was a challenge. And that's kind of just one of those things we learn as we go. And so now they're able to have an ability to they can get a transport license to get those samples and those batches to the testing facilities. Yeah,
they're carving out an exception there, because originally, if you had an interest in a testing facility, you couldn't have an interest in any other medical cannabis establishment. And as Claire said, this makes complete sense that since a necessary component of the testing facility's business is to transport samples, they should be allowed to have an interest in or get their own transportation license, or contract with the transport facility separately. But this was needed. So I guess let's see.
Yeah. This next one right here, Slates kind of touched on it in the medical context a second ago, but this is an important addition. No state agency, political subdivision, or board shall, let's see, they can't promulgate any rule, regulation, policy, or requirement that's contrary to the provisions of the Medical Cannabis Act. So you can't, basically, you're not having this law out there and the authority of the law then contradicted by one of our state agencies, or coming over and regulating over on top of it and really changing what the law was meant to do.
And Amy on the Zoom just asked if that included cities, and the answer would be yes. That would be a political subdivision of the state. So if a municipality did enact a rule, regulation, policy, or requirement that is contrary to the provisions of the Cannabis Act, this provision should act to invalidate that city's new rule, so to speak.
Yes, and Slates, correct me if you differ. There's still the ability of, we all know the opt-outs. I mean, if you were in a city or a county that opted out, this is not necessarily what this is applying to. This is applying to a political subdivision coming in and that was participating in the program and changing the rules on what it was. Now, there is something in the law that says that if you participate in the program, you can't then go regulate it to the point of non-existence. You can't go make it impossible to participate in it because you've put so many additional ordinances or restrictions on what was going on. Like, you can't make the, I guess, for example, the distance requirements so strenuous that it's impossible for an entity to be there if you didn't opt out of it. It's like, so I don't know if you want to elaborate on that, but I think this is more so saying you can't have a city, yeah, like for example, this was an example of the Board of Medicine couldn't come in and add all these additional requirements. The cities and counties are given a little bit of leeway, and this isn't taking that away.
Yeah,
Yeah.
the law is certainly gives local governments authority, and it's specific about what they can do and what they can regulate. So if they did something within that authority, it wouldn't be contrary to what the act says. But well, I don't know, maybe this may be a bad example, but let's say the city of Jackson passed a rule that said you can only sell flour on Wednesdays or something like that. I don't know. Maybe
Or your units don't apply here, you know?
or, yeah, units don't apply here, or you can't sell flour at all in the city of Jackson. I don't know. That would be an argument, but I think that's more about what this is talking about, because clearly the law gives local governments the ability to opt out, the ability to enact some reasonable regulations regulating this industry within their borders, but it can't be contrary to.
And I think that's the key word, is that contrary. You know, because as long as these cities or the political subdivisions are acting within the power that is given to them in that law, they're not acting contrary to it. And like Slate said, there's some very specific things that they are allowed to do. But if they come up with a rule that is something, you know, you can't throw the Medical Cannabis Act out the window and just operate as however you'd like to in one of those. So they still have the ability to put in ordinances. You know, there's some rules on what kind of fees they can charge, or registries, things like that. They can talk about distance requirements. They can expand upon them. And that's what I meant earlier. They can expand upon some of these distance requirements. They just can't do so to the point of making it an impossibility for someone to be there.
Yeah, and that's what Amy asked another question, and it's basically exactly what you just said. That what about a city that did not opt out but created too strict zoning guidelines where no properties are available? I mean, that's opting out after they could opt out, and you know that I think would be subject of a legal challenge. You know, but keep in mind there are a lot of rules in Mississippi about challenging municipal action or county action and very tight windows of time to do so. So, but
that's right.
Under that set of facts there, I mean, clearly what that hypothetical city was doing was opting out after their opportunity to opt out. If they made it so strict that no establishments could be there or could meet their zoning requirements.
That's right. Another part of the updates talks about any cannabis that has less than 0.3% THC that was governed by the Farm Bill. Those things are not part of, they're exempt. This is like your CBDs, things like that. They are exempt from the medical cannabis establishments. And Slate, you from the regulations for them, you actually and I were talking about this earlier today. With respect to the Delta 8 and items like that. Basically, that's just kind of this part of it is just trying to make it a little more clear as to what qualifies to actually be considered governed by it. But this is a messy area, and I think we're going to continue to see it be messy for a little while.
Yeah, and you know, this is the year that Congress in DC is going to revisit the Farm Bill. I know discussions are already underway, and we should see a revamped Farm Bill, I think by September. So it's very likely that some of the less than clear things that have resulted from the Farm Bill will be clarified, and that may help answer a lot of these questions, because you're looking at the definition of hemp is 0.3% by dry weight. You know, we've had the DEA come out and comment on whether it's artificially derived or how the process, getting the compounds and all these things that the more I talk, the dumber I'll sound on the science side of it. But I'm expecting clarity on that from all the way up at the top. And you would think you'd see states start to follow suit. And, you know, clarity is needed for everything. So hopefully that'll happen with this.
Yeah. Another update is that the addresses of prospective and licensed medical cannabis establishments, minus the dispensaries, shall be kept confidential. This is important for security measures. It's not important for the public to know where all the cultivation facilities are. It's not important for them to know, where what's really important is where can you as a qualified patient can buy your medical cannabis. And so that's why those are allowed. But this has just been something that's often adopted by other states as well. And it's really for security purposes. It's just so you don't have, a medical cannabis cultivation or processing facility that that it's openly available to locate and potentially target. And so I think that there's a compelling interest in keeping that private, and it is, I think, for the most part, security. But of course, you need to know where your dispensaries are. So that you'll notice that when the licenses were first being given, they had some information in Excel spreadsheets that were updating everyone on what license were given and that kind of thing. You cannot find the addresses anymore on that. Those have been removed from what you can find on the medical cannabis website.
Right. Yeah. When you go there now, it'll list a cultivation facility and I think just have the county where it's located, but that's the most specific it is at this point publicly. Yeah.
The definition of cannabis waste was an addition to the MMCA as well. So, and then you could see it there. You can find, if you were to search the House Bill 1158 and you see it, the one that is signed by the governor and enrolled, if you were to find it by the bill search, you can read the entire text of it and they identify the important changes or the changes with an underline. So I think it's important that if you're in this industry and you're already operating a medical cannabis business, if you haven't already, it's good for you to read the text of it. It's not that long. It's not nearly as long as what the act itself is, because it's supposed to be read as an addendum and amendment to that in some sense. So it will show you the sections where there have been changes made, and it highlights what was changed about that.
There's a question. EA asks, does this mean legal hemp can be brought into the state and used in products? The way I read the Cannabis Act is that the way it defines the term cannabis and the term cannabis products, it's very broad. So if you're wanting to sell those products in a medical cannabis dispensary, I believe it has to go through the same, it would not be able to probably be brought in from the state. It would have to derive from a licensed processor, tested and all that. I'm not commenting on, this is separate from whether they can be sold, in a CBD store or a non-medical cannabis dispensary. I think, that's a separate conversation that could obviously go a long way, but and I was going to add something. What was the last thing you were talking about, Claire?
The cannabis waste.
Yeah, I think an important thing to point out there is there's a term called cannabis waste and there's a term called plant waste. And as I understand it, they carved out from the term cannabis waste the seeds and the stalks and the stems and included that in plant waste. And if it's not cannabis waste, you don't have to have a licensed disposal entity dispose of it. It still has to be under video surveillance, but I believe that was the important reason for changing or adding that and excluding it from cannabis waste definition so that cultivators could dispose of those types of products from the plant and not have to use a disposal entity to do so, as long as they're still adhering to all the other regulations, video surveillance and whatnot.
So these are some, and this is certainly not an exhaustive list. Slates and I will talk through a few additional ones in a second. But so the last slide was talking about things that were actually in the new law that was passed by the legislature. These are administrative changes in the regulations that have come from our Department of Health. So these are some changes. These changes you'll find in your regulation. And the first one is if you are applying for a business entity license, you only have 3 chances for that license to be a compliant and complete license. And if you already have a license and you've gone through the process, you may remember if you submitted your application and the department needed some more information or something was missing, you got a notification that you had such and such amount of time to provide that information and, you know, continue with their application process. This limits you to they can only go, if you have more than 3 times that you don't have everything they've been asking for, then your application will not move forward. So that's important. Also, if you are a business owner, it's important that you know that all employees must be added to the metric system within 7 days of their start date. So if you've recently hired somebody, then you need to make sure that you're getting all of that filled out and registered within 7 days of that person starting their job. Let's see. We had a change in the definition of the harvest batch. It went from 10 pounds to 25 pounds. And that was a change that you'll find in the regulations as well. And also it's important for you to know, if you go to this website and you pull the May 2023 regulations, similar to what I was mentioning about the changes in the act itself, there is a red line version. You see a clean copy of the regs, and then if you scroll down, you'll see a red line version that is showing you what's different. And so you can more quickly and readily identify some of these changes. Let's see, there's some changes with respect to packaging and what needs to be there. Terpene testing is only required if you are making claims on that about them on your packaging and with respect to your product. At that point, the testing facilities will need to be testing for that as well. Let's see. Also, another important addition to our regulations has been that of a variance procedure. And Slates, I'll let you kind of elaborate some on this, but as well. But you know, our regulations are what they are. It doesn't mean that there may not be a situation with respect to either the construction of your facility or for one reason or another, there's a compelling reason why, as these regulations are written, it doesn't match what your business entity can do, but you still believe that you can operate lawfully outside of it. So you can apply for a variance and have the agency take a look at this very specifically and see if they will make an exception for what your situation is based on facts. And I don't know, there's a very detailed procedure for that, but that is something that wasn't previously available.
Right. And, you know, I preach to clients or just anybody. I mean, I think transparency with the agencies is vital here because it's such a highly regulated industry. And if there's, like Claire was saying, if there's an aspect of your business that doesn't just quite fit within, you know, the peg of this particular rule and this regulation, but you don't see why operating slightly differently, you know, increases the risk for diversion or increases any other kind of security concerns. And
yeah, not creating an advantage or anything like that. It just is.
Yeah. I mean, the department is saying here, reach out to us. We have a procedure in place. Explain to us what you're asking, the exception to the rule, and we will work with you and try to grant you this variance and allow you to operate slightly differently under these circumstances. So yeah,
but it's very important that you do that versus try to operate outside of the regulations without one, because you will get you know, when it comes time for inspection or you know, you have some sort of complaint or whatnot about your facility and the Department of Health comes and takes a look, then if you haven't applied for a variance, but you're not, and even if it would have been one that made a lot of sense, if you haven't done it, then you're not allowed to do it. You have to get that approval. So, and if you get cited for it, you just don't want to go down that road. So the Department of Health has been extremely vocal about the fact that they do want to work with people, and they want to work with these businesses, and they want these businesses to succeed. And so I certainly encourage you to take a look at those procedures and see if you've got anything that you've got a question about. Go this way, because then that if you have a variance, then you're not non-compliant. So.
Yeah, this is definitely a circumstance to request permission rather than ask for mercy later. I mean,
Exactly.
yeah, you may have a good argument if they cite you for something and say, look, this isn't that much of a variation. It doesn't increase risk for diversion. It doesn't give me a competitive advantage, all these things. And they're like, I mean, look, you had a procedure in place. You could have requested a variance. You didn't do it. Sorry. I mean, so yes, please request permission rather than beg for mercy on this one.
Yeah. A few other, what else has changed in the regulations? This is just kind of a catch-all. Slates, this is actually a great time for you to plug your blog, because you have a very extensive, a great article on, a very detailed article on a lot of the changes, but some that are important are some changes in definitions, some changes in the requirements for your standard operating procedures.
Yeah.
What else?
Yeah, I mean, I think that's the gist of it. There's some definitions that were added. I know, like the first thing that comes in biosecurity measures. I think that's measures in place to avoid, infestation of pests and different things like that. And they require SOPs that detail biosecurity measures, and that wasn't in the earlier version. But yeah, as Claire said, we do have a blog. It's buddingtrendsblog.com.
It is a great source for information for sure.
Try to keep everything updated on Mississippi and federal reform and what's going on there, and as well as in other states that are in the region. So
yeah. Speaking of those other states, we have a little bit of this is our last slide. We're going to talk a little bit about cannabis across the country. And let's see. One more thing too, and I don't know if this is another change in the regs. It's just important to know is you can't have no individual can reside at the same address or on the same property where a medical cannabis establishment is located. I think that there were some, obviously that when doing inspections, the Department of Health had come across some of that. And so they've now expressly prohibited that. So it's just good to know you can't be living on in the same property or in the same address or living on the same property where you've got your licensed facility.
Yeah, and one other, I think, worth mentioning that just came to mind, your water supply as a cultivator does not now have to be from a state regulated water system. It can be a private well. And I think the rationale there was we're testing this stuff anyway. So if you use a private well and it adds something that shouldn't be there to your product, we're going to test it. But
yeah,
that was one other change.
Yeah, pest control. They speak to that as well. But yeah, so again, you can go to the website that we talked about earlier. All the regulations are there. You can scroll to the bottom of the documents themselves and see some of those red line changes if you want to short circuit the review. And sometimes, I mean, they're very dense. There's a lot of information there. It's hard sometimes to see what's different than before. And so that is a helpful way to take a look at it. I think for the most part, I don't know, and Slates, correct me if I'm wrong, but I think the Department of Revenue's regulations have been pretty consistent for the most part the whole time. I think that there's been some updates, but on the Department of Revenue's website, they're good about telling you when that date was, when something was changed. And so
I think that's right.
Yeah. So a couple updates here, just if you're interested. We have a few states that have gone adult use this year. It's been exciting and interesting, and we're about a little over halfway through the year. We also have Kentucky joining us with a medical cannabis program. In Connecticut, folks are now allowed to grow there, have plants at home. And there's some details to all of this, but just kind of big broad strokes. In New Hampshire, they're letting out of state patients access their medical dispensaries, which is great. You've got some reform efforts in California and Louisiana regarding prior cannabis offenses. I think you'll see a lot of that across the country anyway, but I think that those two states have had some success with that. And then we've got some crazy things that are happening. Alabama, for example, and I'll let Slates take that one away because I know that you've been following that closely.
Yeah, I spoke to my partner in Birmingham minutes before this webinar just to get the rundown. I've been following it, but basically in June, the commission over there, the Cannabis Commission, announced the license winners. Not long after that, or probably that same day, they were met with a lot of, I'll just use a very kind word, complaints about maybe how the scoring process went. And next thing that happened, it came out that they were putting everything on hold. They were staying everything because they were looking at some scoring abnormalities. I forgot the exact language used, but since then there have been lawsuits filed. There's been a court that's ruled and said everything has to be stayed. The commission has employed KPMG, I think, to come in and do an independent audit. Basically, there's a holding period, and as I appreciate it, KPMG is supposed to be finished with their process in July or the end of July, and then August 10th, there is a scheduled meeting by the Alabama Cannabis Commission where they may announce the new licenses. So, which I can imagine whether they say, here's our announcement, we've gone back, we stick with our earlier announcement, these are the winners, or they announce a whole new slate or some combination thereof. I suspect there will be litigation that follows.
I was about to say, I smell litigation for sure.
Yeah, so I don't know how quickly that's all going to be operating, and which goes back to Mississippi, and it's just amazing how fast, from the passage of the law to product being made available to patients compared to other states. So kudos to a lot of people that made that happen. North Carolina is another state. My firm is watching closely because we have a Charlotte office, and there was some momentum with a bill up there, but everything looks now like it's dead. It's not happening this year. So
yeah, they have an interest, from what I understand, North Carolina too. They have an interesting way that they operate their session. It can go all through the year, like how in Mississippi our session runs at the beginning and first quarter of the year. But I still, I understand the same thing that Slates is saying, is that it doesn't look like they're close anymore. It looked like they were for a minute, but not now.
Yeah, and the same thing with Tennessee, which we're watching closely with the Nashville office, and it was earlier in the year than with North Carolina, but I think it became pretty evident that nothing was happening in Tennessee this year. So
I think Ohio also has some efforts. I need to read a little bit more about them, but I know that they are certainly deserve to be part of the discussion on some legalization efforts there as well. So I will stop sharing my screen and join you guys back. But that's kind of the end of our presentation, and we really appreciate you joining us today. Are there any, do we have any additional questions, or I can see them now. Okay, let's see. There's a question. Let's see. Okay. And Kat, I see that you're answering some of these as well. So feel free to jump in too. Kat, if you don't know Kat Salmon, she's amazing, and I'm sure that in one of our next quarterly webinars, she's going to be sharing lots of information with you too. But I see there's a question about, can a non-cannabis business be located at the same address as a medical cannabis operation? I think that there should be some there, and let me know what you think about it. I think that there has to be some separation. Same address. I mean, we're talking about like suite A, suite B, things like that. I don't think you can. That kind of goes back to, you can't have a dispensary and a doctor's office in the same facility. So I mean, in the same address. So there's some limitations on that. I think that certainly if you are trying to do something like that, or if you're looking at having a non-cannabis related business at a medical cannabis operation for tax purposes, you will not get anywhere with that. But I think it is, they're pretty, each of the cannabis businesses are pretty regulated on what can and can't be there. So
No, I think that's
I
right.
wouldn't say that you could do that. All right. Well, I don't know if Candace is still with us. She was in a bad service area a little while ago, but we thank her and all of her hard work with this organization and for putting this together. And always let us know if there are certain topics you want to hear about. We're going to try to keep everybody informed and doing some quarterly seminars on different topics. But we thought this was a timely one just to get some information out and awareness on updates in the law and regulations. And so certainly, again, this is not an all exhaustive list of everything that's changed. So go and take a look at those regs and the law yourself. But this certainly is covering some of the high points that you really need to know.
Yep. Thank you all for coming, and thanks, Claire.
Yeah.
Enjoyed it.
Thank you, guys. All right.
Y'all take care.